Lordship, I would like to mention item number 4. Matter may be fixed on 18 June. Lordship.
The pair being made by Mr.
Yes, Your Honor.
Learned counsel for the appellant.
Or respondent, Lordship.
Respondent with
Yes.
consent from the other side, respond
Yes.
the matter on
18 June. Lordship.
18.
Yes,
Okay.
18 June.
Fair look.
Highly obliged.
Your Lordship, I beg to mention regarding criminal misapplication number 39, 2024 in criminal appeal number 11 of 2024. Your Lordship, this IA was filed on 26th of April 2024.
When do you want?
Your Honor,
When do you want?
Lordship, it has not been listed. It's been
That's
one.
right. When when you want to be listed?
Till the date when this case will be listed. Tomorrow, day after.
Day after tomorrow, Your Lordship.
Day after tomorrow, all right.
Much obliged, Your Honor.
Mention Mamita.
Yes.
Otherwise, I think.
One.
My appearance, my lord.
Hmm.
My lord, this PL has been filed against the department of against the forest department and the private respondent, whereby the forest department has allowed rampantly to, my lord, destroy the flora and the fauna of the forest area without maintaining the procedure as required under the law. So, my lord, here before come to the documentation, my lord.
Anyway, you show us your locus.
My lord, we are 2 in numbers, and first of all, we are the social activists.
Social activity.
Yes,
Okay.
particularly this Nabum Tama and the Nabum Taga. So various type of many PL which are going on here in this court.
How many PIL you have filed?
Of course, numbers of the PL that 4 to 5 PLs are there in the name.
Pardon?
Around 4 5 PLs.
Around 4 5.
Yes. So
Now you come to this Guwahati High Court rule, PIL rule.
my lord.
Do you have the rule with you?
No, my lord, I don't
Guwahati High
have.
Court
But
PIL rule 2011.
my lord. And I have my lord that as per the my lord this PL rule I have filed my lord.
You come to rule 10. Ace.
Rule. May I know my lord page number?
Page number 491.
Yes, my lord.
Clause Ace.
Rule 10, my lord, introduction
Yes.
for filing the public interest litigation.
Yes.
Clause
Ace.
clause H. H, my lord. If the petitioner has previously filed this should be my lord public interest litigation or prepared the letter of the petition, the detailed proof would be set out in the tabular form given in the numbers of the writ petition, the status and the outcome thereof, my lord.
Where is the
My lord,
reading?
I got in my lord. In fact, I have attempt has been made too, particularly this my lord, I'll take the lordship to page 3. It is still from the para 2. Social activities where my lord
Page 4.
page page 5, my lord. Initially, it starts from page 4, my lord, para 2. The petitioner, my lord, got it? Petitioner number 1 is the social activist based on the Arunachal Pradesh. He served the chairman of Arunachal Pradesh Janakya Santan, an organization involved in advocating for the social welfare and address the public grievances. In his role, he has been active in lightening the issues and relating to the government operation. For instance, he has raised a concern about the allegation irregular in the maintenance of the buses within the Arunachal Pradesh State Transport Department. Additionally, he has called for peer investigation into the various schemes such as under 14 and 15 Finance Commission, noting delay in the charge sheet file over the several years. That the petitioner has been involved in the legal action aimed to promoting transparency and the accountability. He was one of the petitioner in the PL seeking a Central Bureau of Investigation (CBI) inquiry into awarding of the contract under the Horticulture Mission for Northeast and the Himalayan state, alleging that the state government conspired the award of the private company without proper tender process. Beyond his activities, the petitioner number 1 maintained a presence in the social media platform, including the Twitter and Instagram, where he was engaged with the public and shared information related to his activities. However, it is important to note that the petitioner also faces a legal challenge. In February 2025,
No. You tell me whether you have complied with the requirement of clause 8 of Rule 10.
my lord, I admit that, my lord, I have, other than this described, that in the tabular form, my lord, I have not done.
No, not only in tabular form, whether you have mentioned it in other form also in your petition.
My lord, what has been read out other than that, my lord, I admit, no.
And F, you read the F, clause F.
F, well. A specific amendment in the para 5 of the writ petition of the background of the petition with a qualification so far as it may be material to show the competence of the petitioner to the expose of the case. If the petitioner in the organization, the name and address of its office there and the nature of its activities shall be stated. The awardment shall be met, and the petitioner mean to pay the cost if they imposed by the court and on the own
So
undertaking to the
in-
court.
In your petition, where you have mentioned your educational qualification.
My lord. In para 7, my lord, I have mentioned that, yes, my lord, qualification has not mentioned.
Then,
The social worker and the petitioner herein is sufficient mean to pay the cost and if imposed by the court and further undertake to petitioner will be compliant.
then,
So, my lord, in such situation, my lord, now I have come to the conclusion that, my lord, I will come with you, my lord, all required as per the procedure is maintained in, my lord, Guwahati High Court rule, my lord. Otherwise, my lord, notice can be issued and in the meantime.
No.
Okay, my
Then
lord.
you come to your annexures. These photographs were taken in the year 2023, right?
My lord.
Page number 20 of your petition.
Yes, my lord.
23.
1812,
And
2023.
where is
Till-
the document? Where is the document to show that the forest land was diverted illegally without obtaining permission from the central government?
Exactly, my lord. That particularly, my lord, on the basis of the on the basis of the representation, the attempt has been made. So, my lord, at this instance, my lord, I may be allowed to, my lord, withdraw with liberty. So, my lord, so that I can come with, my lord, with all the procedure required under PL.
So we will impose cost upon you.
My lord,
For approaching the court in this way.
my,
Mr. Tapin, what is your
my
submission?
prayer would be, my lord, at this stage, my lord, this
Lordship is only pointed
cost
out
may be exempted. my
for coming in the PL lordship.
The present PIL petition has been instituted by the petitioner. Petitioners, Nabam Tama. Both are same name,
Yeah.
Nabam Tagam.
Yes, Nabam Tama and Nabam
Inter
Takam.
alia assailing, inter alia raising a grievance with regard to the construction of a double lane route to provide airport connectivity from Donipolo Airport, Itanagar to Naharlagun Railway Station via Sona, Juli and Durbung. Full stop. It is the contention of the petitioner that the said construction activity is being carried out without complying with the requirements of the forest regulations. Also, subpara, on a perusal of the contentions made in the PIL petition, we have noted that the same is so made in clear violation of the provisions of the PIL rules to litigate. Violation of the Guwahati High Court bracketed public interest litigation bracket over rules 2011. Full stop. Subpara. On a query made to Mr. C. Modi, learned counsel appearing for the petitioner, Mr. Modi has submitted that the manner as prescribed under the said rules of 2011 has not been complied with by the petitioner in filing the present writ petition. Further, we see that the material particulars requisite for sustaining the grievance raised in the present PIL petition has also not been disclosed in the present petition. Full stop. We are of the considered view that the present PIL petition has been so instituted for the purpose of initiating a roving inquiry into the matter, inasmuch as the petitioner has miserably failed to bring on record any material particulars in the matter. Full stop. Mr. Modi, on being queried, has submitted that the petitioner, you are agreeable to file better particulars. The petitioner would be required to file better particulars for sustaining the grievance raised in the present petition, present PIL petition. Full stop. At this stage, Mr. C. Modi, in view of the above lacunas existing in the PIL petition, submits that he be permitted to withdraw the same with liberty. Full stop. While accepting the said prayer of Mr. C. Modi, learned counsel for the petitioner, we find that the frivolous for filing the present frivolous PIL petition in clear violation of the provisions of the said rules of 2011, the petitioner would be required to be imposed a cost accordingly. A cost of rupees 10,000, 5,000 is imposed upon the petitioner for filing.
Mr. Tapin, do you have any advocates welfare fund here?
Here the bar association.
What is the name?
What's the put Itanagar permanent bar association?
Just write it down. Somebody ask them. The said amount would be deposited by the petitioners to the account of the so and so. Full stop. On deposit of the said, full stop. Mr. Modi has submitted that how long will you take to deposit that amount?
1 week.
1 week. Mr. Modi has submitted that the said amount would be deposited within a period of 1 week. Full stop. In view of the above, the petitioner is permitted to withdraw the present PIL petition with liberty as prayed for.
Oh, bless.
A bar association.
Yes, Lalo, are you ready to argue the matter?
Yes, my lord. Me, my lords.
Section 6 and POCSO and 377 IPC.
Who is for the respondent number 2? This is one. Okay. Yes,
My lords, this appeal challenges the judgment and order dated 22/7/2024, pronounced by the learned Special Judge POCSO Bomdila in POCSO case number 6 of 20.
The, but Mr. S. Tapin, learned counsel for the appellant, senior government advocate appearing for the appellant. Also, none has appeared for the respondent. Also, the present appeal has been instituted by the appellants assailing the judgment and order dated 24/1/2024, passed by the learned single judge in WPC number 597/2023, allowing the petition, allowing the respondent herein to proceed on except passed by the learned single judge, directing, deemed acceptance of the resignation submitted by the respondent number 1 herein from his service. Also, this court wide order dated 27/2/2024, passed in ISC number 35 bracketed AP 2024, had stayed the effect and operation of the interim direction. State the effect and operation of the said judgment and order passed by the learned single judge. Also, today, when the matter was taken up for consideration, Mr. Tapin has submitted that the respondent herein had rejoined his services by way of submitting a joining letter dated 28/5/2024. The said joining of the respondent in his services has been accepted by the government, and further, the wide order dated 27/8/2024, the period when he had remained out of service after submission of his application for resignation from service, has also been regularized by granting to him earn leave for the said period. Also, in view of the above position, the directions passed by the learned single judge widely order, judgment and order dated so and so has been rendered infructuous. Also, accordingly, there being no live issue required to be considered in the present writ appeal, we are of the considered view that the same would be required to be closed. Accordingly, considering the fact that the petitioner has already resumed his services, which would mean that he has given up his claim for being permitted to resign from his services, which was contested before the learned single judge, the present writ appeal stands closed.
If the effect of that learned single bench judgment, that has to be interfered. Otherwise, that
You have already done it. It's finished.
no, they are directed to deemed acceptance.
That's why you said,
Other,
because now that he has given it up, he has resumed his services. Where is that question of his deemed resignation?
Actually, what I'm submitting is if learned single bench judgment.
In view of the above position, the application submitted by the petitioner for proceeding on resignation has spent its force, and the same cannot be now acted upon by either by the petitioner or by the respondent authorities. So in view of the above position, in view of the above position, the order passed by the directions passed by the learned single judge, while the judgment and order dated 24/1/2024 in WPC number 597/2023 has been rendered null and void.
Closed.
Full stop.
That
In
will be
view of the
technically
above
that will be
position-
correct.
In view of the above position, the present writ appeal stands closed. Morning, it will be late. Interlocutory application. I 35 AP 2024 in view of the orders passed today in writ appeal number so and so, no further order is called for to be passed in the present interlocutory application, and accordingly, the same also stands closed. I to recommend you.
Yes,
My lord, if I may, my lord, this appeal is against a judgment by the learned special court Bomdila, whereby about this convict was sentenced doing this, my lord. He has been convicted under section 6 of POCSO Act, my lord, read with section 376 of the IPC, my lord. Now, my lord, the
So, okay, I don't,
So both of you are on the same plane. He also does not have the numbers.
I have it. Actually, our office just
so now you tell me whether you can argue the matter on the basis of this paper book or not.
no, I can.
No,
Yes, because I have to refer
Okay.
page number.
heard Mr. Singh, learned counsel for the appellant, and Mr. V. Dado, learned additional PC for the state respondent number 1, and Mr.
Respondent number 2,
Ginny for respondent number 2. Mr. Dado, learned additional PC pointed out that his office has misplaced the earlier paper book furnished to him by the registry, and thereafter he obtained one Xerox copy of the paper book from the learned counsel for the appellant. But there is no pagination in the aforementioned paper book, and as such, he is not in a position to argue the matter. And accordingly, it is provided that recessal list the matter when.
My lord, day after tomorrow, kindly. This
Day
matter,
after tomorrow.
yeah, my
Okay, day after tomorrow. In the meantime, recessal furnace. List the matter day after tomorrow. In the meantime, recessal furnace a new paper book marking the pagination to Mr. Tado, and list the matter day after tomorrow.
Have this, my lord.
Yes.
My lord, I'd like to mention item number 10, my lord.
10.
On 10, on behalf of Deep Mangling, my lord.
My lord, he is out of station due to his father's medical treatment, my lord.
Item number 10.
10, my lord.
Okay, you are for the petitioner,
Yes, my lord.
Mr. So learned counsel, appearing on behalf of Mr.
Deepangin.
Deepangin, learned, conducting counsel for the petitioner. You inform the other side
Yes, my lord.
with consent from the other side. Price for listing the matter. After it,
My lord, 3 weeks, my lord.
after 3 weeks,
3 weeks, my lord.
after 3 weeks. Parallel,
My lord, there is an interim order, my lord. It may be continued.
interim order, pass or less, continue.
Further, my lord, I beg to mention item number 20, my lord.
25,
20, 20, my lord.
20.
Here I am the state respondent, my lord.
Yes,
My lord, this matter may be fixed after 4 weeks, my lord.
or you inform the appellant.
Yes, my lord, I have
Mr.
telephonically
Gopala,
informed Mr.
learned
Kosi, my lord.
counsel for the respondent. With consent from the other side, price for listing the matter after 4 weeks.
My lord,
Parallel.
heavily opposed.
Your Lordship, I'm from the petitioner, Your Lordship. There's an interim order which we may be continued, Your Lordship.
Interim order. Ms. So-and-so, learned government advocate, with consent from the other side, press for listing the matter after 2 weeks. After 2 weeks, so as to enable her to file affidavit in opposition, as she has already received parawise comment. Parawise comment. Parallel, interim order passed earlier, shall continue.
Your Lordship, I would like to mention item number 5. We have taken consent from the other parties, Your Lordship. The matter may be adjourned for today and this is after 1 week.
You are for
For the respondent, Your Lordship.
respondent, Mr.
For Mr. M. Tanga, Your Lordship.
Learned counsel appearing on behalf of Mr.
M. Tanga, Your Lordship.
Learned counsel for the respondent with consent from the other side, press for listing the matter after
1 week, Your Lordship.
1 week. Parallel.
Much obliged.
I'm sorry. One item number is there, my lord, 10, my lord. So somebody has mentioned it, my lord. There is a urgency, my lord, on last
Item
occasion
number,
also,
item
10,
number,
my lord. It's a contract matter, my lord. It's a time-bound matter, my lord.
item number 10.
10, my lord. And there was no stay also, my lord, on the last date. my lord. So if they have taken time, my lord, that is okay, but stay may not, because since there is no stay on the last order, that may not be continued. I was there in court number 1 to mention one matter. He has not told me that he will mention it.
I told you this
No,
morning.
But
I informed
but
you-
it was when the matter will reach, then only you will say.
I informed you this morning.
But anyway, we are there, but the urgency is there, my lord, because
If urgency is there, we'll fix a short date then.
short date, my lord. And since there was no stay on the last order, my lord, the last order is dated, my lord. Because it will otherwise this tender will expire, my lord. It's going to expire on 27th.
Okay, interim order passed earlier, shall continue.
It is not there, my lord. On kindly
Maybe-
raise the last order, my lord. No, last order, there is no interim order. He has to file
maybe.
a fresh petition, my lord.
Maybe it will continue.
My lord, I have made a mention only because my lord, Mr. Deepangin is
Oh, no, all right, all right.
on medical grounds. I
Okay.
think
No, that is okay
you must
for,
understand that.
no, that is okay for taking time, that is okay. But since there was a no stay order, my lord,
No. Stay order is earlier. Stay order is not vacated.
but it has not, it
No,
was.
today
Which day?
it is being mentioned that it will continue.
And it meeting.
Medical case में
So interim order passed earlier, shall continue.
My lord, when the date is given?
Pardon?
Date.
After 3 weeks. It
My
gets
lord, the tender will expire, my lord.
But Mr. Pangin is out.
But the tender will expire, my lord.
You settle the matter between yourselves.
I have an objection against his gay. Against the,
Then after
against
2
taking,
weeks,
Yes, ma'am.
on 13, my
After-
lord, on
after 2
13,
weeks.
it may be fixed.
when?
13, my lord. Friday.
My lord, the problem is that my lord, Mr. Pangin is out of station because on account of his father's illness. My lord. So there is no main problem. Otherwise,
And here the problem is the NIT will expire, my lord. The matter will become infructuous. That is,
There is stay, my lord. There is no question of.
no, since now this is GEM portal, my lord. 13, my lord, 13.
After 2 weeks. After
A fixed date may be given, my lord.
will, yes,
13 Friday.
okay.
Oblige, ma'am.
I would like to mention for on this matter, I filed one criminal division petition. For this
When?
today.
When do you
I
want?
have, that item number 40, some other cases connected to the same case, so this will be taken up together with some other case,
Item number?
40.
14. Somoto criminal petition.
Yes,
Today?
yes.
Okay.
My lord, I beg to mention item number 21.
21.
Yes, my lord. My lord, I have taken consent from respondent.
You are for respondent.
I am for the petitioner.
Respondent.
I am for the petitioner.
Petition.
Yes, ma'am. I'm listing
So-
after 2 weeks.
After?
2 weeks.
After 2 weeks, Mr.
Encarga.
Learned counsel for the petitioner. With consent from the other side, first for listing the matter after 2 weeks. Fair look.
Plus.
Yes.
Your Lordship, I beg to mention item number 17. Your Lordship, I'm from the petitioner side, seeking 3 days time to take a fresh step to respond in number 4 to 8.
Mr.
Respondent number
Your
4 to
name-
8,
Your name,
GR Romching.
learned counsel for the petitioner. Submits that he may be granted. How many times? How many days?
After 3 days.
3 days to take fresh step upon the respondents. You inform the other side?
Lordship, I'm from the petitioner side. Petitioner. For the
You inform the other side?
Yes, your Lordship.
When?
This morning.
This morning?
Yes, your.
With consent from the other side. Okay. It's after 4 weeks. Yes.
Much obliging.
Affidavit,
Pleadings are complete.
leading complaint. Tomorrow.
No issue.
Okay. Heard Mr. Arsoner, learned counsel for the petitioner, and Mr. Estopin, learned senior government advocate for the respondent authorities. Mr. Estopin submits that he has already filed the affidavit in opposition and pleadings completed, and the matter may be listed for admission hearing. Accordingly, it is provided that Justice shall list the matter for admission hearing tomorrow.
My lordship. Lordship, I'm impugning the order dated 21/5/2025 passed by Deputy Commissioner Senior. Order is at phase number 43.
Okay. Caveat to be heard, caveat extensive research. So this order is passed in compliance of the order of this court.
Yes, order of this court.
Then
Yes, your lordship, the petitioner in WPC 513/24, they have filed an representation before Deputy Commissioner Siomi. On strength of that representation, the petitioner, the respondent in here, they have
whether
approached.
that representation is part of the record.
Yes, representation is part of that petition. petition number,
no.
WPC number
Whether
513 of,
that representation is part of this record.
no, Lordship, I did,
No,
yes.
is it not necessary?
Lordship, that is not necessary.
Why?
Lordship, this order.
Because this court has directed to dispose of that representation.
Yes, Lordship.
And on the
Right.
basis of that, the learned deputy commissioner has passed the order.
Yes, Lordship.
And that representation is not part of the record.
Yes, Lordship.
How we will decide the issue?
Yes, Lordship. Consequent to that, order 11/11/2024, the deputy commissioner has commenced the proceedings to dispose of the order of this honorable court. To dispose of the pending representation.
You produce that representation before this court. Then we will see
Lordship, then may take up tomorrow, Lordship.
tomorrow.
Yes,
Okay. Heard me, sir?
REMO.
Pardon?
REMO.
Learned counsel for the petitioner. And Mr. Ratan for learned additional essay for respondent number 1. And Mr. Soikia for respondent number 23.
The connected petition where you still pending, that may be taken away.
With this.
Yes.
The question of the maintainability of the validity within the petition is being objected by me. Because it's a late petition proceeding matter and he is from the civil petition and under section 115 of the civil matter. It's not maintainable matter. The order has been disposed of matter by this honorable court pursuant to the matter section 21 notice under the Land Acquisition Act matter for claims and objection matter. That was not complied by the matter, the collector matter. That's why we have approached before this honorable court to matter redress our claim and objection matter. Then thereafter matter on the basis of the honorable court's order matter, that order has been impugned, order has been issued matter. But let it come up tomorrow, my lord. Tomorrow we will clarify.
No, whether the repetition is required to be tagged with this
No,
matter?
no, my lord.
Not necessary.
Not necessary, my lord.
Not
I
necessary.
will produce the, my lord, the claim and objection application also, my lord, before this court, my lord.
This civil revision petition under Article 227 of the Constitution of India, read with section 115 of the CPC, is referred by the petitioner challenging the correctness or otherwise of the order dated 21/5/2025 passed by the district collector cum deputy commissioner Tato, Xiaomi district, Arunachal Pradesh. A perusal of the order dated, impugned order dated 21/5/2025 indicates that the same was passed on the basis of one order passed by this court in WBC number 513 AP 2024 dated 11/11/2024, whereby a coordinate bench of this court directed the deputy commissioner to dispose of the representation filed by the petitioner to the deputy commissioner on when it was filed
14/10/2024.
on 14/10/2024. But the said representation is not placed on record. The learned counsel for the petitioner submits that the matter may be listed tomorrow so as to enable him to file the aforementioned document, aforementioned representation by way of
Affidavit.
by way of an additional affidavit. Where is accordingly allowed, this is the matter to me.
Reply.
Lordship, this application is regarding question of the revocation of the
Yes.
GST cancellation order. Your Lordship, as this court, I have filed the additional affidavit as ordered by this honorable court, Your Lordship.
Yes.
to submit the stay order.
Mr. Boru, on the other day, you have been directed to obtain instruction in respect of the
My,
in respect of the
My lord.
annexer number. Annexer number 5, 6, and 7.
My
Whether
lord.
that instruction is available with you.
That instruction I have not, they have not provided any instruction, my lord. They've only said that they don't have any the objection regarding the restoration order if passed. My lord. If the similar order is passed, they do not have any objection, my lord.
You have no objection.
No objection, my lord.
On the other day, the counsel for the petitioner has pointed out exhibit annexer 5, 6, and 7.
Yes, my
That
lord.
to show that to contend that he has already deposited the fine amount,
My lord.
and thereafter you have been asked to obtain instruction.
That instruction I have not received, my lord. They are only saying verbally that, my lord, whatever it is, it's all correct, and they have no objection if the honorable court passes similar order as passed earlier, my lord.
Pardon, sir.
M. Hali.
M.
Hali.
Ali, learned counsel for the petitioner, and Mr. Boro, learned standing counsel for the respondent number.
1 and 2, my lord.
Respondent number 1 and 2. The learned counsel for the petitioner submits that the petitioner herein has been running wood-based factory at Sanglang 9th mile, which is under lease agreement between the actual proprietor, Sri Ingkap Taizo, and the present petitioner. Due to insufficiency of supply of raw materials, the said industry was not functional for almost 1 year. During the period of 2023 to 2024, and he has not received any notice from the respondent authorities to file the GST return. And the petitioner operates the wood-based industry and relies on GST registration for business operation, including issuing invoice and claiming input tax credit. And by the impugned order dated 4/12/2023, the respondent authorities have cancelled the GST registration of the petitioner, citing show cause notice dated 11/10/2023, which the petitioner has never received in any of the prescribed mode, that is registered post, email, or GST portal. Thereafter, The petitioner has paid the GST with fine totaling rupees 2,74,225 rupees for delayed filing of the return. And the payment was received by the respondent authorities on 19/3/2025 and 24/3/2025. And thereafter, the petitioner has filed on representation for restoring, for revocation of the cancellation of his GST registration number. But the same has failed to evoke any response from the respondent authorities, and being agreed, the petitioner approached this court by filing the present petition, praying for issuing direction to the respondent authorities to restore the petitioner's GST registration number being GSTIN 12AF OPT 1605H3ZI. The learned counsel for the petitioner further submits that counsel for the petitioner referring to Annexure 5, Annexure 6, and Annexure 7 submits that he has already paid a sum of rupees 2,74,225 rupees, including the delayed fine amount, and thereafter one representation. No, thereafter the petitioner filed on representation to the respondent authorities for revocation, now for restoring his GST registration number, but the same is yet to be disposed of. Then accordingly, he contended to set aside the cancellation order at page number
15. Your Lordship,
Annex 2, at page number 15 of the writ petition. Mr. Borough, learned counsel for the petitioner, learned counsel for the respondent number 1 and 2 submits that similar kind of petitions have already been disposed of by this court, and he has no objection if this court is inclined to allow this petition in terms of in the line of the aforementioned petitions. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also perused the representation dated 21/4/2025, and also the Annexure 5, 6, and 7, which indicates that the petitioner has already paid the amount to the respondent number 1 and 2. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to allow this petition by setting aside the cancellation order dated 4
December 2023.
4/12/2023. 4/12/2023. The respondent authorities are directed to verify whether any amount is due from the petitioner, and further to and if any amount is due, the same the petitioner shall pay the same, and on payment of the aforesaid amount, the respondent authorities shall restore the GST registration of the petitioner. And the aforementioned exercise has to be carried out within a period of 15 days, within a period of 2 weeks from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent authorities within a period of 1 week from today.
Okay. Much closer.
Obliged, my lord.
Presence and provision may kindly be recorded in item number 10.
What
That it was
objection?
mentioned,
What objection?
that I have an objection for granting time. That much. That which have to.
No, earlier you have consented.
Yes.
Sorry,
And my objection, my.
sorry. Next item. This matter,
It's already one.
it will take time.
Minimum 30 minutes. He will take 30 minutes.
Okay, then we will start at 2.
Yeah, but this time is also. up.
Matter pertaining to principal seat for delivery of order, item number 1, bill application number 1173 of 2025.
Petition allowed.
Obliged.
My application. Well, the matter pertaining to the compensation issues. But first of all, my lord, before applying myself into the merit of the argument, I'd like to inform this honorable court that there is a one similar matter, WPC number 591 is, my lord, yet to be, my lord, disposed of. This is the analogous matter. And now, my lord, I will try to, my lord, clarify where the collaboration between the two cases. Here in this case, my lord, basically, we are here I'm here challenge the order passed by the deputy commissioner, wherein the deputy commissioner has rejected my claim that I have the land within the land to be compensated by the, my lord, acquired by the Indian Army. In due course of time, my lord, what has been revealed that there is a one land allotment, land ownership certificate. The land ownership certificate has been issued to the private respondent. Therefore, my lord, on coming to know that this land ownership has been issued without my knowledge and without the, my lord, following the procedure to be, my lord, adopted to acquire the land possession certificate. Therefore, I am challenging that particular, that is the main cause of the road, challenging the particular main, that is the land ownership certificate in WPC number 591. Therefore, my lord, my submission is that if WPC number 591 is disposed and a success, my lord, everything, this will, I am honestly submitting, my lord, this present case will be automatically, my lord, collapse. And if I success in that case, my lord, that nothing will be remain to be, my lord, discussed to decide this case. And so far this WPC number 591 is concerned, my lord, it's come up for more than twice, and this private respondent, these are the same party, they have showed the party time that Same matter was came up yesterday in the item number 15, my lord. And they are yet to file their counter affidavit. So this, my submission would be, even if attempt is made to dispose of this, still, my lord, the final decision adjudication will be required under WPC number 591, my lord. Therefore, my prayer is that let both the case be leased together. Otherwise, my lord, because
591 of the year
2024, my lord,
2024.
my lord, wherein I have challenged the procedure adopted by the Deputy Commissioner, how the private respondent were, my lord, allotted to land allotment certificate. Otherwise, my lord, so far the POCSO is concerned, the bone of contention of the parties is the land occupied by the army at the Alo. In due course of the time, my lord, that the one committee was formed, this is the private respondent, for the boundary issues. And
So anyway, we cannot decide this writ petition without deciding the writ petition number.
exactly, my lord, that is my contention, my lord.
That is factually not correct, my lord. The fact is, during Chinese aggression in Arunachal, some lands were acquired by the Indian Army for emergency purpose. Thereafter, what had happened, the petitioner filed a title suit before the POCSO. The title was decided in favor of the respondent for 49.6 square meters. 63 square meters of land. Now, that was acquired and the compensation was to be paid. And what had happened is, my lord, when this disbursement thing started, the petitioner came in and started assailing the process. Once the title is decided, my lord, in my favor, I will have no objections. You have not taken the leave of the court even to challenge if your right is violated, your constitutional or fundamental right is violated, that you have not done. Number 3 is that even that 591 2024 writ petition has been filed suppressing this writ petition. No whisper has been made in 591 about this writ petition.
So the writ petitioner is same.
Writ petitioner is same.
My lord, same.
And you know, when I go through the lecture, the oath affidavit, by that time he was 72 in 2022 when he filed the writ petition. Now also in 24, he was 72 years old. How these kind of things are being allowed, my lord?
Well,
That is one.
that is subject to
And
argue
my-
to the
No, no,
writ
no,
petition
it's not
5.
question of subject to
9.
answer, my brother. My lord, kindly see. I'll demonstrate from here. My lord, only kindly come to page 181. In suppose, my lord, assuming or admitting, my lord, even if he succeeds, he says he should be tagged together, but that will be a disputed question of fact. And read proceedings under 226, my lord. Title cannot be decided. Even then, my lord, I just demonstrate his case from here, my lord. This two particular, this is the title suit, my lord. Page 181 of the writ petition. Page 145, 185 is the order, my lord. And I request my lord to indulge the page 185, the operating portion of the title suit. Para third.
Para number?
Para 3 of this page 185.
So this was title suit.
Yes, madam. 49.63 square meter of the land was adjudicated, decreed in our favor. and these has still in force and he has not challenged it. They kindly see, in view of the above reasons, I hereby order and decree that the adequate land compensation against an area of 49.63 meters of the private land shall be paid to the landowner of the PDBRATBC villagers within a reasonable period from the date of this decree, and order without which the area measuring 49.63 acres, sorry, I stand corrected, it will not square meters, acres, occupied by army, which is a private land belonging in the PDRATBC village, will revert back to its owner. Now, my lord, kindly see in one more page, I'll demonstrate where he has no right to maintain this writ petition is, my lord, page 191, my lord, kindly come.
So when the other item was fixed,
Only
My lord, after 2
yesterday,
weeks.
yesterday it was listed. My lord, still I saw this
no,
because
that's all right.
Yeah.
Can we take both the matter together and discuss
tomorrow,
together?
tomorrow we'll finish it tomorrow, my lord.
Okay.
Because this is a frivolous litigation, my lord. This cannot
No,
be. My
that's
lord,
all right.
kindly see
No, let us try to dispose of both the petition
tomorrow. my lord.
tomorrow.
But still, my lord, I request, my lord,
91.
you 191. My lord, kindly see. His categorical statement on 12/02/12/2021, my lord. Kindly see this order passed by Deputy Commissioner.
Mm.
It says on the very outset, on the very one outset or one set, I don't know. One set, Sri Kento Ori stated that he has no issue with the PDBRATBC getting the land compensation, and also that he is not claiming the title of the land occupied by the army. His only grievances is that in the land map of the army occupied area, his private land at Hisam village is included and the same should be carved out. Now, my lord, two things are coming up. One, if you have the land, barring these 49.63 square kilometers of the land, your immediate remedy is by filing a title suit. One. And number two, you are barred by estoppel. You have categorically made a submission saying that I have no objection to the land compensation given to the respondent. Estoppel is there, my lord. So therefore, you cannot raise this. Once you are stopped legally creating a bar against you without challenging the title suit decreed in favor of the respondent, which is still in force, my lord. You don't have any.
How this order came to be passed?
Because
Order
he-
dated 2/12/2021.
My lord,
The title was the additional district judge has decided the title in your
Title,
favor.
yes.
Thereafter, what happened?
thereafter, he again started raising that some 30,000 square meter land he has in that. On the other hand, he is trying to confuse the court. The petitioner is trying to confuse the court, saying that he do not have any grievances over 49.63 acres of the land. But he says, my land is still occupied by the army. So therefore, the remedy, the Reed court cannot adjudicate, my lord. This will come disputed question of facts.
Hmm.
My lord, I have an answer on that part.
No,
So
I
it will
have
take
placed the
lot
record,
of
my
time.
lord. I have placed the record. If that is the case, so we are ready for argument, final argument tomorrow. This is definitely a frivolous.
You
petition.
are appealing for
For private respondents.
private respondent number
7.
7. So decree was passed in your favor.
Correct, my lord, in my
Thereafter, he raised the issue before the deputy commissioner.
deputy commissioner.
And before the deputy commissioner, he has admitted that he has no objection in releasing the
Correct.
compensation in
Correct.
your favor.
My lord, even page 197 kindly come for a moment. I demonstrate this case, my lord. My lord, I think my brother was not there on that day. Kindly come to 1703/2022 or the annexure K. It is at page 197. Two paragraph I will read, my lord. Third paragraph, my lord. Both the parties appeared before the Deputy Commissioner, West Siang District, Alo, on 3/2/2022, and the date of hearing was fixed on 23/2/2022. However, the counsel for the petitioner prayed for adjournment of the hearing fixed on 23/2/2022 due to his preoccupation. The hearing was refixed on 4/3/2022. Next paragraph kindly come. The counsel for the petitioner submitted that his client is not demanding compensation for the 49.63 acres of the land to be acquired for army, but is confined with the demarcation of land stroke boundary for the army, but is confined with the demarcation of land boundary to be clear between army occupied area and the private land of Sri Kento Esiori at Hisam site before releasing of compensation as per the map approved by Sri S. Pao, the then Deputy Commissioner West Siang District Alo, and prayed for carving out of his land from the proposed acquisition. Now, therefore, my lord, why you should be aggrieved against me? It is your categorical submission. It is recorded by a quasi-judicial body, the Deputy Commissioner. Whenever, my lord, even in the Land Acquisition Act, if the Deputy Commissioner is presiding under Section 11, then he discharges the function of a quasi-judicial. So therefore, he has rightly done the qua-time action. And accordingly, this decision has come. So therefore, my lord, there is a complete estoppel against him. No legal and fundamental right has been violated. My lord. So therefore, my lord, kindly fix this matter. Tomorrow we finish it off.
My lord.
Heard Mr. Modi, learned counsel for the petitioner, and Mr. T. Tara, learned counsel for the respondent number 7, and Madam Ite for respondent number
For official respondents, Proceed.
You CGC.
1 to 5,
Yes.
and POCSO
4 and 6.
you are for 4 and 6. Then Madam for 1,
Lordship,
2,
I am for
1, 2, 3,
3
and
and 5.
5. Then Mr. K. Lawyer for respondent number 4 and 6. During the course of deliberation, Mr. Modi, learned counsel for the petitioner, submits that the petitioner has filed another writ petition being WPC number 591 AP 2024. And the subject matter of the present writ petition is same with the aforementioned writ petition, and both the writ petition may be listed together so that both can be heard and disposed of together. Accordingly, it is provided that the session lays the matter tomorrow along with the WPC number 591 of 2024 for final consideration.
In the admission column. In admission column.
No, it is already in admission.
Yes. Read.
All right.
Matter number 6.
Yes.
Your Lordship, I'm on behalf of Miss N. Anju, Lordship. My case.
Fernando is absent today.
Yes, Lordship.
Mr.
K. Meena, Lordship.
Learned counsel appearing on behalf of Ms. N. Anju, learned amicus curiae.
Yes, Lordship.
Amicus curiae. Price for listing the matter after
A week, Lordship.
as Ms. Anju is not present in the court due to why she is not present?
She has some personal difficulties, Lordship.
Due to her personal difficulties. There is accordingly allowed recusal is the matter after
A week, Lordship.
after a week. Mr. Ite,
Yes,
learned
Lordship.
additional preferred present for the respondent number 1.
Yes, Your Lordship.
Said respondent.
He said yes.
This is under section, conviction was under section
307, Lordship.
307.
Yes, Lordship.
Whether the respondent informant is party in this proceeding.
Lordship, perhaps they have not been implemented. Yes, Your Lordship. Respondent number 2.
Respondent number 2.
Yes, Your Lordship.
Whether he is represented by any counsel.
No one is representing.
No one is.
Yes, your lordship. Otherwise, your lordship, the notice has to go, at least notice has to go, whether the notice has been issued or not, that we don't know.
Notice was issued. White ordered it at 16/9/2024.
Service
Then,
report was awaited, your lordship.
One more thing.
Yes, sir.
The person concerned has already completed 10 years on 6/12/2024.
Yes, your lordship.
There was a direction of this court to obtain instruction whether the person is still in the jail or not.
Yes, that instruction, your lordship, we have already informed this court earlier, your lordship. He was not in the custody during the trial, your lordship. During the trial, the accused person was not in the custody, so it's still not completed, your lordship.
Acha.
If he was in the during the trial, if he was in the custody, then your lordship, the 10 years should be completed, your
He
lordship.
has not completed.
Yes,
10
not
years.
not completed, your lordship. And your lordship will find the order dated 8/4/2025, last order, your lordship. Here, your lordship, the
So
service was
he
awaited.
He has completed 7 years, 5 months and 3 days.
Yes.
On 11/12/2024.
Yes.
Okay.
Seven years, 5 months in 3 days. Your lordship will get the status report because your lordship, on last occasion, we are directed to give reminder to the officer in charge, Doimuk Police Station, regarding service to respondent number 2.
Pardon?
Your lordship, on last occasion, your lordship, we were directed to give reminder to the officer in charge, Doimuk Police Station, regarding service to the respondent number 2, your lordship. On 8/4/25, in last para, my lord.
Or take down. Office note dated 23rd/4/2025 indicates that notice upon respondent number 2 could not be served as he could not be found out in the given address. And presently he is residing at the G extension, Narleon. Accordingly, it is provided that press step be taken upon the respondent number 2 by registered post with AD and also by usual process within 2 working days from today. Place the matter after 4 weeks.
Yes. Obliged, your lordship.
Blessed.
Number 7.
Lordship, I have filed an RTI application and reply has been received. Now I need to file a rejoinder of affidavit filed by the respondent.
You will file a rejoinder.
Yes.
Lordship, they have already taken 4 weeks last occasion. So Lordship, this is a urgent matter, Lordship. So I have requested my friend also to file it as early as possible. And we have consented this matter to be listed next week on Thursday, Lordship, 12th.
Next week.
Next week.
Next week.
Next week.
Okay. Pardon, Mr.
Pardon.
Learned counsel for the petitioner and Mr.
JG.
Jezene, learned counsel for the respondent number.
Lordship, private respondent, Lordship.
Private respondent number.
6, Lordship.
Respondent number 6. Private respondent number 6. And Madam, you are for State respondents. Learned additional senior government advocate for the respondent number 1, 2, 3, 4, and 5. 4 and 5.
1, 4, 5.
The learned counsel for the petitioner submits that he obtained some documents. Obtain some information by filing RTA application, and he will file a rejoinder affidavit and price for granting him one at time. Here is accordingly allowed. This is a list of matter on
12. 12.
12.
12.
So interim is there, interim may be continued. Interim is there.
Interim, okay, interim order plus order shall continue. So, your plea is that this doctrine of sameness is applicable here also,
Yes.
right?
Yes.
But to examine whether this doctrine of sameness is applicable or not, you have to place on record both the FIR, which are registered at North Lakhimpur PS and also at Itanagar, or which PS?
Yes, sir. At the Itanagar one, we have
Itanagar.
annex.
Itanagar is available, but
Yes.
North Lakhimpur FIR is not available.
That we will have to procure, my lord. That we will have to procure, but my lord,
Unless you file that FIR, how will test the matter?
because my lord, in this regard, if I may kindly indicate page number 18, my lord. This is a status report by the,
No, status report will not do. You obtain the FIR.
we can obtain the FIR. Actually, my lord, we also have annexed the order dated before the learned CJM.
Of?
Lakhimpur. The
No.
case is pending.
That is there, that's all right. But unless you produce the FIR, we cannot test it.
My lord, then can we be given some time? Actually, my lord, there is also our prayer for interim also.
Pardon?
Interim also, my lord.
No, first we have to ascertain whether this doctrine is applicable or not. If it is applicable, then we will consider your prayer.
Yes, my lord, because why we are praying for this interim was because, my lord, the sections from the materials we have annexed, although the FIR we have not annexed, the materials that we have annexed herein, my lord, sections are same, even the complaint, gist of the complaint, everything is same. Only,
We'll see.
pardon, my lord.
We'll see the FIR. Heard Mr. Z. Talu, learned counsel for the petitioner. And also heard Mr.
El Kurdu,
Learned
SGP,
counsel for the respondent number.
1, my lord.
Respondent number 1.
Yes, ma'am. Sole respondent is the SIT.
What's up? Is Talu, learned counsel for the petitioner submits that in connection with the same subject matter of Crime Branch Police Station case number 13 of 2021 under section 153, 153A, 500, 505, 506, 34 IPC. Another FIR being North Lakhimpur PS case number, another FIR was filed before the officer inserts North Lakhimpur Police Station, upon which North Lakhimpur PS case number 1264 of 2021 under section 153, 153A, 500, 505, 506, 34 APC has been registered against the present petitioners. But the aforementioned FIR has not been placed on record. No, but it appears that the aforementioned FIR has not been placed on record. And and it appears that it is the contention of the petitioners that the FIR, which one is earlier,
The Lakhimpur PS.
that the FIR of North Lakhimpur PS case number 1264 of 2021 was registered on 29/11/2021 and the crime branch PS case number 13 of 2021 was registered on 26/11/2021. And in view of the doctrine of sameness, the registration of the second FIR is impermissible. And in order to ascertain whether the aforesaid doctrine will be applicable or not to the facts of the present case, perusal of the FIR of North Lakhimpur PS case number so and so is found to be necessary, and accordingly it is provided that Mr. Talo, learned counsel for the petitioner, shall place on record the aforementioned FIR by filing an additional affidavit. Place the matter after 2 weeks.
And meanwhile, my lord, if records from the crime branch is also called for, my lord.
Pardon?
Records from the crime branch, second FIR, Itanagar is also called for, my lord.
No, that FIR is a part of the record.
Right.
We will consider it later.
Lordship, we have a small prayer for our interim. We have a small prayer for our interim. Because Lordship, we are already facing trial before the learned court at Lakhimpur. Now, if the FIR.
Interim prayer of the petitioner will be considered on next date.
Matter.
All right.
If it is under drafting or if it is under drafting. It can be taken up in the next 2 days.
I object, your lordship. Lordship, kindly go to the last order. In the last order, it was very clearly mentioned that in case if they fail to file affidavit by this date, the matter will be heard. And you know, this is a very urgent matter. My whole system, the whole machinery is in standby. 34 people are without any source of income. So I pray that the case may be heard, or if they are seeking time to file affidavit, I think the interim may be considered. I only pray that
Considered our district, it will become infructuous. It will be of no use.
you also will see the interim order which I am assigning to this petition.
But Mr. Lohan,
Yes.
you tell me, by going by this order, can it be said that any opportunity of being heard was afforded to the petitioner?
Depends on our feeling.
Pardon?
They can be taken after filing our listings, affidavit membership. It will not take time. We need tomorrow also. It can be heard.
Tomorrow?
Yes.
Okay, tomorrow. Heard, Mr.
Okay, Raja.
Learned counsel for the petitioner. Also heard Mr. Lohan, learned senior government advocate. For the respondent authorities, Mr. Lohan submits that affidavit in opposition of the respondent authorities is being prepared, and he will be filing the same during the course of the day. Today you are going to file it?
Maybe
Tomorrow.
Tomorrow,
Tomorrow.
no problem. We'll be able to file it now.
Okay, let's list the matter tomorrow at 2 p.m.
Your lordship, I pray that it may be for disposal for tomorrow.
Pardon?
For disposal of the matter.
We will consider it. Huh? Kita finish করলাম বেশি তো নাই আর
May I please, Your Lordship? Your Lordship may kindly allow us 2 more weeks, Your Lordship.
2
2 more weeks to file our counter.
more weeks. You
Yes,
have not filed your affidavit.
not yet, Your Lordship. We are yet to receive our instructions. Paraway's comment.
Convocation, last chance was given. It's almost more than 8 months, and they're not filing affidavit in opposition.
Yeah, Your Lordship is in transit.
Will grant you time, you pay some fine amount,
Yes, Your Lordship.
cost.
Your Lordship, the affidavit is in transit, Your Lordship.
Pardon?
Affidavit is in transit, Your Lordship. We have talked to
Transit.
the officials, yes, Your Lordship. It will reach only you, but Your Lordship, 2 weeks.
Pardon, Mr. Lazi, learned counsel for the petitioner, and Ms. Sangita, learned government advocate for the respondent authorities. Ms. Sangita submits that the affidavit is on transit. And she tries for granting 2 weeks time. However, Ms. Sangita is granted 1 week time to file her affidavit in opposition. In the event of failing to file her affidavit in opposition, the court will proceed to hear and dispose of the matter on next step without the affidavit of the respondent authorities. This is the matter after 1 week.
Obliged.
Obliged.
This is very much in red. This is the offshoot of WPC number 195 of 2025. While WPC number 195 of 2025 was filed, all the bail orders were made as annexure. After perusing the entirety of the annexures, the coordinate benches taken the suamoto cognizance against those bail orders. Now, after that, record has been called for. Initially, the cognizance was taken only for
Mr. Martin, is there any provision in CRPC for taking so motu criminal petition? Is there any provision in the CRPC for taking so motu criminal petition?
suamoto.
Yes.
Yes, if anything, any illegal thing is found and detected.
No, is it provided in the CRPC?
Huh? Sure.
CRPC.
CRPC. Suamoto is inherent power.
So motu is inherent power.
Inherent power.
This is regarding
Nowhere
cancellation
it-
of bail application.
It is nowhere it is described.
No, it is for cancellation of the bail order.
Ah, yes. When, when illegal things and illegal things is detected.
This is not for cancellation.
Pardon?
This is not for cancellation. The initial writ petition is not for cancellation of matter. There is no provision as such under the CRPC for taking so much about it.
Then how it is registered as so motu writ petition, so motu petition?
In the writ petition, madam, the first one item number, first item is writ petition. Writ petition is for madam, the reinstatement of the petitioner services. Madam, petitioner was suspended under suspension, placed under suspension, for which madam, the revocation order was not passed. Basing on that, madam, after release of the petitioner from the custody, who has been detained in the police custody for more than
48 hours.
Yes.
Yes.
Then in that case, madam, we moved then this honorable court by way of writ petition for madam, the reinstatement in the service in the madam, department. In the meantime, madam, the perusing rightly pointed out, perusing the annexures. When and madam, the petitioner was released from the custody, that was madam used, perused now. Then madam, in the read proceedings, madam, this so motu cognizance has been taken by. So therefore, madam, my respectful submission is, madam, there is no provision it says under the code of the criminal procedure that so much of cognizance can be taken. Madam, of course, madam, exercising the 220 power under 226, madam, that is another aspect. It is not basically for the madam, the cancellation of the bail. It is not the case of the state, madam, for cancellation of the bail. It is not either of the parties, madam, who are victims, alleged victims in the case, wherein, madam, this, they prepared, madam, before this honorable court for cancellation. It is not the case of the state, madam, or the prosecutions for cancellation of the bail. madam.
Then where is the order for registration of this Somoto petition?
Order dated, madam,
Order dated 8/5/2025. Please the Suamoto order in WPC number 195 AP 2025. Page 1, 2, 3. Dated on 8/5/2025. My lord.
So what happened about this WPC then?
Madam, WPC, if lordship peruse, this is for madam, the revoke, madam, I am challenging the suspension order, madam. Suspension order of the petitioner. The petitioner was, madam, deal day, the petitioner suspension has not been revoked. There is a madam, the provision under the madam, the code of the, madam, the Central Civil Service rules, wherein, madam,
Within 90 days,
90 days review has to be
90
done.
days over.
Madam, long months back, madam, it is over. And more than, madam, the.
Thereafter, it has not been
No.
reviewed. Whether service memo is furnished.
No, ma'am. Even, madam, my salary has not been also enhanced, madam. Once DPC, madam, sorry, review is
No,
done,
you are getting this subsistence allowance.
subsistence allowance 50% at the time of, madam, the passing order in.
You are
uh,
getting it.
Yes, ma'am, that I'm doing. So therefore, madam, there is no provision as such, madam. Of course, the judicial power under, madam, 226 is one thing, madam. But there is no provision as such directly, madam, is specified in this code of the criminal procedure, wherein, madam, therefore, madam, my point submission is, there is no provision as such for the direct, madam. It is not the case of the prosecutions too, madam, for cancellation of the bail.
Mr. Partin, you are appearing for state.
I'm standing counsel of the Guwahati High Court. So I'm representing in the case of the Suamoto case. Because
You
this
tell
case,
me, is there
this
any
case-
provision in the CRPC regarding this Somoto? Yes, court can register Somoto revision petition against the bail order. That is criminal petition.
this is, yes. In that case, court has taken the cognizance against the illegality which the bail was granted. Because there is a clear-cut notification issued from the Guwahati High Court that whenever bail hearing is heard, the victim and the informant must be met as party. Then, while the interim bail was granted, that time also informant and the victim were not heard. Then, when the bail was made, interim was made an absolute, that time also the informant advocate was absent. So during the absence of the other party, that is the advocate, whether it can be made an absolute. And apart from that, while the case was, record was called for, it was found that on 18/1/25, similar order, bail order was passed, and there
the seven accused have been granted bail. On in that very order also, there was not present even the
That's,
informant as well as the
Mr.
advocate.
Patel, that's all right. Now, what does criminal petition has to do with this writ petition? Why both the matters are taken together?
Now, while the writ petition was heard, on the basis of the annexure enclosed in the writ petition, court has taken the suo cognizance. Court
No,
has
that's all
taken.
right. Let us segregate both the matter. We will hear it separately.
And then, now it has been bifurcated. It has been now registered as in re, not mixed up with the one WPC number 195 of
No, both are
2025.
listed together today. Criminal petition with WPC number 195.
Huh? Yes, it is in the segregated. It should be segregated.
But if in criminal petition law, if that is allowed and the bail is cancelled also, then in that case also writ petition will become improper.
How?
Because because he has been already released from the lawsuit custody, so therefore they are asking for reinstatement in the lawsuit service because he is under suspension law.
No, he will be governed by the service rule.
Yes, madam, that is wrong submission.
No. Suppose if his bail is cancelled, he'll send back to the jail lawsuit again.
That is the future
Then-
course of action, my lord.
Then lawsuit, the questions of reinstating is does not arise.
Madam, exactly, if lordship reviews the my writ petition, madam, this is my pleaded case. Madam, though I am residing, my lord, inside the custody for my lord, more than 90 days. Madam, review has to be done by its own course of action, madam. The department has to review the, my lord, as per the.
Yes, no. Is it the proposition of law that once you are in custody, even after elapse of 90 days, the authority, disciplinary authority will not review his suspension?
No,
order?
that part is not yet examined law. That part is not, even notice is not issued in the law, item number 15 laws. Even not notice is issued law. Whether it's reviewed or not lawsuit.
Okay,
That has to be reviewed, that's their lawsuit. But whether it has been done or not, I have to take instruction on that part. What I'm submitting is lawsuit. Suppose say if he is sent back to the jail lawsuit. Then questions of lawsuit revocation of suspension doesn't arise.
I do not have any connection with WPC number 195 of 2025. My operation, my coming to this court is start from the taking of cognizance on Swamoto against the bail order issue, against the passing of illegal bail order. So I am not concerned with 190, WPC number 195.
Lawsuit review lawsuit. If it's not reviewed lawsuit, what prayer they are asking in item number 15 lawsuit? They are asking for the revocations of the suspension lawsuit because review is not done lawsuit. Suppose if he has been sent back to the jail lawsuit, how the suspension can be revoked lawsuit? That's the question. Therefore, it's connected to each other. So far, review is concerned, even if he is in custody, review has to be done. That's another part of it. But what they are asking is the revocation of the suspension lawsuit. Suspension is not yet revoked lawsuit. Review is not done. Therefore, they are asking for the revocation lawsuit.
Yes, that is the ground of, that is the proposition of law laid down by Supreme Court.
Yes.
That is it.
They are asking for the revocation of the suspension.
Unless you review it, the court will definitely strike down it.
That's their lawsuit.
Then,
Suppose if bail, this cancellation is not also, if his bail is cancelled also, he'll be back to the custody again. The whole question of revocation of the suspension.
No. Once it has not been reviewed within the period of 90 days, then his right accrues for getting the suspension order.
So
cancelled.
therefore, lawsuit,
It cannot be tagged with this matter, criminal matter, cancellation of bail.
lawsuit,
If this criminal petition will remain pending for another 1 year, then you will not review his suspension order.
no, review has to be done.
Then
lawsuit, what I'm submitting is the lawsuit in item 15. Notice may be issued lawsuit.
okay, let us issue notice. Let us segregate both the matter.
Lawsuit. But substantially lawsuit. So for revocations of the lawsuit suspension.
Maybe there may be some
Even
relation.
if he is in custody lawsuit, even if review is not done also lawsuit. It doesn't mean
Mr.
suspension has to be
Mr.
revoked.
Kapil,
lawsuit.
we are all aware of the cancellation of bail.
Oh.
Under what circumstances it can be cancelled.
Oh.
So it is easy to grant bail, but it is not easy to cancel bail order.
That part lawsuit, I have nothing to say. Lawsuit.
Then-
That is cancel or not cancel
Then-
lawsuit.
So once you have not reviewed his suspension order after a elapse of 90 days, he is right accused here to get the suspension order cancelled.
So that part can be examined. Lawsuit.
Definitely.
But lawsuit, I am trying to point out lawsuit, substantially lawsuit. If he is in custody, even if he
No,
is
no, no,
not
no,
done
no.
also
That
lawsuit.
cannot be. That cannot be. That cannot be.
This can be segregated lawsuit up to this whole court.
Yes.
Then my lord, I might read petition, my lord, may I submit my.
Wait, first we pass order this in this criminal petition. Thereafter we will hear.
If lordship permits, may I make a short submission?
Yes.
I'm appearing for my client Bulan Marik, my lord.
Pardon?
Bulan Marik, my lord, the accused.
In this criminal petition.
Bulan Marik, yes, my lord.
Okay.
My lord, the criminal petition is about non-adherence of the mandatory provisions under POCSO Act, and also as well as in terms of the judgment on Deepak Nair judgment, Deepak Nair versus State of Assam, and also in the light of, my lord, Delhi High Court versus my lord, G minor versus Delhi State of Delhi, my lord. And also in terms of, my lord, model guidelines, which was issued, my lord, by the Ministry of Women and Child Development, Government of India, my lord, in terms of 2.2 clause, my lord, where it is specifically mentioned, my lord, children have the right to be heard in any judicial and administrative proceedings affecting them. They must be given a reasonable opportunity to express their views in all matters affecting him, and this must be taken into account. He should also be allowed to provide initial and further information, views, or evidence during the proceedings. Children have, Roman 2, my lord, children have the right to information about the case in which they are involved, indicating information on the process and outcome of the case, unless the lawyer considers that it would be contrary to the welfare and best interest of the child. It would be best if the lawyer coordinates with other persons or agencies concerned with the child's welfare, such as the support person, so that this information is conveyed in most effective manner. Victims should receive the most appropriate information on the proceedings from all their representatives, and the assistance of a support person appointed under Rule 4, subsection 7, most often constitutes the best practice in ensuring that full information is conveyed to the victim. My lord, in terms of this, my lord, model guidelines, my lord, and in terms of the guidelines set by Delhi High Court, my lord, and in terms of the, my lord, judgment, Deepak Nair versus State of Assam, my lord, all procedures, mandatory procedures have been followed, my lord. Followed, my lord.
While granting bail.
While granting bail, my lord.
Then why this petition has been registered?
His petition has been registered, my lord, the alleged non-adherence, my lord, of the mandatory provisions. But actual position is it, my lord. We have served a copy of the bail application to the public prosecutor as per the guidelines, my lord.
And the informant complaint, my lord, CWC. And the victim was under the care and protection of the CWC, my lord. We have served copy to the CWC, my lord. And we have implemented them as a party respondent. And the serving directly to the victim, my lord, it's not our domain, my lord. We have to serve the PP, my lord. PP has.
Yes. That is the direction issued in the Deepak Nayak case.
Yes, my lord. It is the PP, my lord, who is to inform an IO, and IO has to serve the victim, my lord. The question of personally serving the victim does not arise, my lord. Therefore, my lord, we have not violated any mandatory procedures while filing the bail application, my lord. And regarding, my lord, giving opportunity of hearing, my lord, it is up to the prosecution, my lord, and the PP, my lord. Therefore, my lord, there is
Who is appearing for the state? You are. But the notice was served upon the informant before granting bail.
Like to clarify every procedure which has been laid down in the Deepak Nayak case, my lord. If your lordship allows.
Followed here.
Not followed, my lord, here in this case.
Why?
Your lordship, the procedure prescribed in the Deepak Nayak case, your lordship will find in the notification number 2, it speak about 439(1)(a), wherein it says it is obligatory for the informant to give an opportunity at the time of hearing in certain offences, and the offence which has been classified, it says when the victim age is below 16 years, then informant obligatory part. That is, your lordship, that has to be read along with the third point of the third direction of the Deepak Nayak case, where it has been held that if there is any allegation of the POCSO or not or and it was conjunctive, your lordship, it has to be reached conjunctive 439(1)(a), then it shall be mandatory to victim, parents, or support person shall be given an opportunity of being heard, and they should be implicated as a party in the case. They must be given an opportunity. So far as your lordship CWC is concerned, CWC doesn't come under the purview of support person, which is clearly given in the rule of POCSO Act, your lordship, POCSO rule. For support person, there are certain procedures are there which is not there. No doubt CWC is the complete informant, but so far as the other Deepak Nayak direction is concerned, that has not been complied with. And your lordship, there are instances, your lordship, which has dealt by this honorable court, wherein even the victim was present, but in the bail order, the submission of the victim, the counsel was absent, submission of the victim was not reflected. On that aspect also the bail was cancelled. And your lordship, the other part, so far as the suo motu part is concerned, my lord, as my lord has pointed out, 439 subsection 2, it speak about the High Court and the Court of Session has a power to cancel the bail which has been granted under the chapter. And that same has been discussed by the Honorable Supreme Court. The High Court always has a power, suo motu power. If the order, any order has been passed in violation of the, your lordship, violation of any law, legal aspect, your lord. Here, your lordship, that has been violated. Victim has not given an opportunity. CWC was only, their only role was confined to informant, as an informant. They are not the support person under the, your lordship, rule of POCSO Act.
It's up to the prosecution, my lord. How can I personally serve the victim? It is there in the guidelines, my lord.
Notification, my lord.
My lord, kindly come to Roman 1 of the C, my lord, guidelines.
Roman 1C of?
C of notification number 17, dated 15 March 2024, my lord. C Roman 1, my lord. In every bail application, criminal appeal, criminal revision, criminal petition arising from cases involving offences under the POCSO Act and those covered by section 439 1A CRPC, the registry shall serve a copy of such bail application / criminal appeal, criminal revision, criminal petition to the public prosecutor, my lord, concerned who in turn shall forward the same to the investigating officer concerned or the officer in charge of the concerned police station through email and also as hard copy, requiring the officers to apprise the victim, guardian, support person regarding filing of such proceedings before the High Court. Malad. Specific mention of High Court. Even it is not meant for the trial court. And there is nothing about the accused or the accused counsel personally serving the victim.
Yes.
Roman 3.
So the notices were served to furnished to the PP.
PP, my lord.
Then
And
what
also,
PP had the-
as well as, my lord, informant complainant.
Yes.
Under whom, my lord, the custody was under the protection and care of the CWC, my lord, the informant complainant. On ensuring participation in the hearing, my lord, I cannot compel the victim, my lord, to participate in it.
Definitely you cannot.
Yeah.
So,
I use late. I want to make some submission on this. Here, my lord, no, this procedural aspect has been violated, it has been fully complied. But we have to see the rules frame under the POCSO Act. Under the rules says, my lord, here in the case, my lord, that support person was provided by the CWS. Suppose person who was representing the informant as well as technical. Well, if we see the definition, my lord, that who is the support person? Now, rule 2F of the rules. It says, my lord,
Mr. Whether all the persons to whom notice were issued are before this court today?
Yes,
I
ma'am.
am telling
Yes,
two
ma'am.
of them.
Yes, ma'am.
I am representing one.
Yes.
I am representing four of them.
All are this 10 persons are represented.
10%, serial number 3, I am representing.
Serial number 3.
Serial number 1.
1.
I am for serial number 4 and 6.
Mr. Sunar is 4 and 6. 4 and 6.
I am for my lord 3.
3. You for
1.
1. And Mr. Rabha for?
I am for, my lord, 1.
No,
Sorry?
the person concerned.
Person concerned, man.
1.
Bulang Marik, my lord.
Bulambari. Criminal petition.
1.
Main
Original repetition.
read petition.
I am for the accused person at serial number 5, 8, 9 and 10.
And 7?
No, see, I am in pen now. Sorry.
You are for 7?
Yes,
And for respondent number 2, Devi Atara. You are. So, you were interested to file any objection here? Not required.
As a matter of objection, so we may file. In my case, I'll be filing in the
You'll
form
be
of
filing?
affidavit. Yes, because in our case, initially, in my case, my lord, bail application, it was filed on bail application, my lord, it was filed on 3rd January 2025. By serving the copy to PP as well as to the informant, who herself is the CWC chairman. And at that time, my lord, victims were under CWC's
Custody.
my lord. And thereafter, on 18th
January 2025, matter was posted for hearing. And upon hearing only, my lord, this bail order it was passed. So to bring those on record, we'll be filing affidavit.
My lord, may I make a proposition, my lord? Instead of keeping it pending, my lord, what I would like to make a proposition is that, my lord, I also rely on a judgment, my lord, of National Investigation Agency, NIA versus Lamki Iralo, my lord. Whereupon, my lord, the Honorable High Court Division Bench has, my lord, remanded the matter back to the trial court by giving an opportunity to file a bail application afresh, my lord, by following due procedures of law, my lord. And till that, my lord, they be protected. They should not be protected, my lord. Ultimately, my lord, lordship will either set aside with observation or without observation. There's lordship's prerogative, my lord. That preposition, if lordship accepts, my lord, we will not be aggrieved, my lord. Finally, my lord. It has been done in NIA case, my lord. Eleven and 13. Excuse me. 11, 13. NIA judgment. Hmm. 11 and 13.
My lord, here in the case, court has appointed amicus curiae for the victims, and whereas he is absent today. Amicus curiae has been the Dicky Pangu have been appointed as a amicus curiae for the victims. But today, he is absent.
So let us fix the matter after a week. In the meantime, if you want to file objection, you can file. Heard Mr. Partin, learned senior counsel assisted by Mr. Learned counsel, standing counsel for the Guwahati High Court. And Mr. S.R. Rava for respondent number for
Bulang Marik Malu. Accused Bulang Marik. Main respondent number. 1, 1, 2, 3.
Security.
where it is recorded. Like you are as on main respondent.
My lord.
Your name is?
My lord.
No, your client's name is?
Bulang Marik, my lord. Bulang Marik.
INRE versus Bulang Marik, and the rest were implemented.
Accused Bulang Marik. আপনি রিঅ্যাকশন করুন
And you give your names to court master. And also the name of the person concerned you are representing. And also heard Mr. Your name, please? M. Dozy. Learned counsel appearing on behalf of Mr. Deepangin, learned. Amicus curiae.
Yes.
Amicus curiae. For the victims. Mr. Sonar, learned counsel for the respondent number so and so, and Mr. You. Submits that any other person interested to file objection?
Yes, ma'am.
All.
Yes.
The learned counsel for the respondent submits that they will be filing their objection. Objection and press for granting 1 week time,
May I pray for a shorter date, my lord?
shorter date,
6th of June, my lord.
6th of June.
Yes, my lord.
6th
6th of June.
You will be able to file a objection or within 6?
My lord.
Okay. Let's list the matter. Whether record was called for,
Yes,
Records is already formed.
records are available.
record received. Let's list the matter on 6 for final consideration. In the meantime, the learned counsel for the respondents may file their objection.
Highly obliged.
Now, in WPC,
This inlay may be secreted from the WPC.
yes.
Because
Let's
there's no-
segregate this matter from the WPC number 195 AP 2025.
My lord, I declared on 6th, my lord.
Out of station. Then when?
My lord, my lord, 11 or so, my lord.
11. 11. Okay, 11.
May I please, Your Lordship? My lord, impugn order in this writ petition is page number, my lord. Page number, my lord, 18, annexure 1, my lord. Impugn order, my lord.
Here notice has not yet been issued.
Notice. So therefore, my lord,
Okay,
this is.
so let notice go.
Yes.
Mr. Tapan, you want to file all respondent, you want to file objection or the affidavit? You will be filing your affidavit. Okay. Part Mr. M. Kato, learned counsel for the petitioner, and Mr. S. Tapan, learned senior government advocate for the for all the respondents. It is submitted at the bar that notice in this petition is yet to be issued. Accordingly, it is provided that let notice be issued to the respondents returnable when, Mr. Tapin? After 1 week or 2 weeks? After 1 week or 2 weeks?
My lord, that will be too long, my lord. 2 weeks time. my lord.
Okay, 2 weeks. Step be taken, no, as all the respondents are represented by Mr. Tapin.
Madam.
Learned senior government advocate. No formal notice is required to be issued. However, extra requisite copy of the petition will be furnished to him during the course of the day. List the matter after 2 weeks. In the meantime, Mr. Tapin, learned senior government advocate, may file his affidavit in opposition.
Madam. I'll send extra copies.
Yes.
Deeply please.
Next matter.
Item number 16 may be adjourned because on the last occasion I was asked to furnish a copy, but I could not locate the advocate. Today I have found, I will serve the copy. Matter will fix after a week.
After?
After a 1 week.
After 1 week.
Yes.
If possible, Your Lordship, can it be fixed on Monday, 9, Your Lordship?
Yes.
9.
All
Okay.
right. Tomorrow I will furnish.
Heard Mr. T. Tapak, learned counsel for the petitioner. And also heard Mr.
E. Menjo, Your Lordship.
learned counsel for the
Respondent number
respondent.
2.
Whether any state respondent is here?
Yes, state is.
Who is representing state? None appears for the respondent number one.
She
State
was-
respondent number one.
She was here only. Tijini, madam.
Mr. Tapak submits that though there is a direction to furnish extra copy of the petition to the learned counsel for the respondent, he could not furnish the same, and he will be furnishing the same today during the course of the day.
Yes.
And he pressed for listing the matter after a week. After on
9.
9th. We are allowed this is a list the matter on 9th.
Highly appreciated.
My lord, let us take up first IA.
Yes.
My lord, the IA is relating to perjury committed by the respondent. My lord, in this case, my private land was occupied by Assam Raipur in the year 1968. And it was handed over to ITBP in 2004. And since then, the land is under the possession of ITBP. The total area of land is 187 acres. Your Lordship, may I please to look at page number 44. Page number 44. Annex 3. Well, this is a letter written by the Commandant 10 BN ITBP to Deputy Commissioner, Upper Subansiri District, Dapur region. Here, one table is there, my lord. My lord, may I read para 2 of this letter? In this regard, also refer discussion held with second in command of this unit with your good self on 21/9/15 in your chamber. During the meeting, decision was taken on the subject that survey will be conducted in the month of October 2015. But after lapse of half month, no any action taken or scheduled to be taken by your office has not been received till date. Higher HQers of ITBP is pressing hard to liaise with your good office and finalize the transfer/allotment case of land held physically by ITBP in Upper Subansiri District of Arunachal Pradesh. Para 3. It is therefore once again requested to your good self to look into the case personally, initiate the survey process at the following 4 locations in favor of 10 BN ITBP. There is a table, my lord. In first column, that is serial number. Second is location. Third is area under possession. And below that, 187 acres has been mentioned against TCC. TCC stands for Tama Chung Chung. It is the name of the area, my lord. So this clearly shows that 187 acres is under the possession of ITBP, as per their letter, my lord. Let's see next page, my lord. This is also a letter written by Commandant 10 BN ITBP Police to the Deputy Commissioner. Para 2 is relevant, my lord. Para 2. Para 2 says, my lord, in the subject letter, the measure of TCC post has been mentioned at 1.87 acre, which is grossly wrong and far less than the land site handed over to ITBP by Assam Rifle on paper 187 acres. Here, the commandant ITBP is trying to explain the error committed by the deputy commissioner. Instead of writing 187 acre, it was written 1.87. That has been clarified by this letter, my lord. So it is very clear that 187 acre is under the possession of ITBP since 2004. My lord, let's see what they have said in the affidavit. It is in page number, it starts from page number 33, my lord. In the same IA. The relevant para is 5, page number 35. Para 35, sorry, page number 35, para 5. It says that with regard to statements made in para 3 of the writ petition, the deponent states that under reply are matter of facts that Assam Rifles was under the occupation of land at TCC and after that ITBP took the possession, the land at TCC, but the same is never demarcated by the concerned authority and hence it is incorrect to say that the whole 187 acre of land is under direct possession of Assam Rifles and ITBP thereafter from 2004. This is not correct statement of the respondent, my lord. Here, the respondent is given false information before this honorable court. As per records, 187 acre is under their possession. Now they are saying here that it is not correct to say 187 acre is under their possession. This is false information, my lord. And secondly, my lord, page number 41. Page number 41. Whereas 17 in the same IA. Whereas 17, my lord. That the deponent respectfully submits that the instant writ petition is based on imperfect, unauthenticated, wrong and misleading outcome of chain compass survey, which had not been accepted by the respondent number 1, 2, and 3. It says that the survey report submitted by the deputy commissioner, that was not accepted on the ground that it was surveyed by using chain compass. But my lord, after this survey, fund was sanctioned for 4 crore 86 lakhs. So they cannot say that it was not accepted. So this is false information or false evidence on oath given for this honorable court. This affidavit was filed in 2024. Fund was sanctioned in 2021. They knew well that the survey report was accepted and fund was sanctioned. Despite of knowing that, they have stated that that was not accepted. So this is a false information given by the respondent number 1, 2, 3, and 6 before this honorable court, my lord, which is a punishable offense under 229 of BNSS. My lord, in this regard, I would like to relate judgment of the apex court.
Well, the relevant paragraph is 24, 25, and 26. Paragraph 24, 25, and 26, my lord. Paragraph 24 says, my lord, we do not wish to comment in detail upon the intention behind making the aforesaid interpolations. At this juncture, all that is required to be assessed is whether a prima facie case is made out that there is a reasonable likelihood that the offense specified in section 340, read with section 195, 1B CRPC has been committed, and it is expedient in the interest of justice to take action. From the above discussion, it is evident that the handwritten modification made by the petitioner in column 12 of the balance sheet dated 1999-2008 is a significant alteration from the terms as used in the original documents. Hence, we find that a prima facie case is made out that the petitioner has fabricated evidence for the purpose of the special leave petition proceedings before this court. Next paragraph. We find further that prima facie case is also made out against Mr. R.K. Agarwal for having shown in his affidavit before this court as to the veracity of the facts stated and documents filed in special leave petition civil number 3309 of 2018, even though he had relied upon the original auditor's report, which did not contain any handwritten interpolation in his evidence before the trial court. Para 26. In similar circumstances, a three-judge bench of this court in R. Karufan, advocate in Re, had authorized the Registrar General of this court to depute an officer to file a complaint for perjury against the respondent therein. Accordingly, we direct the Secretary General of this court to depute an officer of the rank of Deputy Registrar or above of the court to file a complaint under Section 193 and 199 of the Penal Code 1872 against the petitioner company in a special leave petition civil number 3309 of 2018 and Mr. R.K. Agarwal before a magistrate of competent jurisdiction at Delhi. The officers so deputed is directed to file the aforesaid complaints and ensure that requisite action is taken for prosecuting the complaints. So, in a similar situated circumstance of the case, when perjury has been committed before the Supreme Court of India, in that case, direction has been given for lodging complaint. But in this kind of matter, court has to lodge complaint. Now, in another similar situated circumstance.
Oh, not necessary to multiply the decision. Yes, Mr. Kato.
This is the disputed facts, my lord. My lord, we have categorically filed an affidavit in opposition to the main writ petitions, my lord. And basing on that main.
Maybe this is your document.
Yes, madam.
This page number 44 and 45.
Page number 44 of IA, madam.
Yes.
Yes, madam.
Whether before filing the affidavit, you have taken instruction from them
Madam, admittedly,
in respect of these two documents.
no, my lord. Admittedly, my lord, that my lord, instruction I have not taken, madam. So therefore, my lord, may I pray that, my lord, at this stage, my lord, this is the one thing which has been brought to the notice, my lord. So therefore, my lord, may I pray that, my lord, some more time may be granted so that I can come with the detailed affidavit how this has happened, my lord. My lord, sometime what happened in the ITBP, my lord, the post, my lord, the.
No, you should have already obtained the instruction in respect of
Yes,
these two
madam.
documents.
This, my lord,
You know that this IA is pending before the court. Here is for rescission of
My-
case against them.
IA,
For
reply
further,
to the IA has been filed, madam.
pardon?
Yes,
Reply to the IA has been filed, madam.
yes, ma'am.
Mm.
They have
Reply,
filed-
madam.
How you have dealt with these two documents in
Yes,
your
madam. So
affidavit?
therefore,
reply?
madam, that has not been, madam, specifically, just now I have noticed, madam, that has not been specifically mentioned, madam. So, madam, if lordship peruse the, madam, the affidavit in reply filed by the ITBP, madam, at page number 7, internal page number, madam, the continuation page number is 61, madam. I'm sorry, madam, the affidavit in reply
Hmm.
to the, madam, the IA,
Hmm.
page number 61, madam.
Hmm.
Para 8, madam.
Hmm.
That with regards to the statement made in paragraph 5, in the paragraph 5, the alleged this petition, the respondent of the IA, the answering the defendant submits the false allegation repeatedly by the petitioner. ITBP is a government agency and a part of the Ministry of Home Affairs. It is completely wrong to say that the statement given in the affidavit are false. In this case, it still has to be said that only 4 acres of land is in the possession of the ITBP, madam. Ground survey may be conducted by any government agencies, madam. Therefore, the contentions of the paragraph 5 is wrong and hence denied, madam. Categorically, madam, we have replied in the affidavit, madam.
Maybe, but this document will prevail over your
Yes,
oral
madam.
statement.
Yes, madam. So therefore, madam, this is how this has been happened, madam. By this affidavit, madam, it is not conclusively, madam, conclusively, madam, concluded. That so, madam, short may be given, that may be given, madam. I'll come with the specific instructions to that aspect, madam. Sometime what happened, madam, the first, madam, the approval and pre-approval.
No, I think proper instruction you have not received.
Yes, madam.
You see, these are the Secretary Home, Ministry of Home Affairs.
Correct, madam. Madam, the short that may be given. I'll come to with that specific instruction how this has been happened, sir. This has not been properly explained in the affidavit, madam.
Mr. Koyan?
My lord, the
Subject to-
affidavit has already been filed. This is pit case to be disposed of, my lord.
No, that's all right. But the question is whether this person, this respondent number 1, is the Home Secretary of the country.
Yes, madam.
Obviously,
Whether it was brought to his notice or not, these documents.
my lord, obviously under instruction, this affidavit has been filed. Obviously, they might have gone through the contents of my IA and thereafter a reply has been filed. So there is no meaning to give another chance to file another affidavit because they have clearly, of course, in evasive manner, not specific.
Not specific.
Clearly, they have clearly replied some of the issues. But as per records, this is a clear case of commission of offense of perjury, my lord. Because PAN has been sanctioned in 2021, page number 48, my lord. Despite of sanctioning of fund, they have started saying that the measurement, otherwise assessment made by the district authority that has not been accepted. Not been accepted means that is completely wrong, my lord. On the basis of assessment made by the district administration, this fund has been sanctioned. Now what they are doing, this fund has been sanctioned for 19 acres, my lord. And amount is 4 crore 86 lakhs 2,987. Now they are trying to reduce this amount. And the area has also been trying to reduce for 4 acres only. So I cannot follow them. Either you pay the compensation as prepared, because I have given no objection certificate also for 19 acres. Now I will not give another no objection certificate for 4 acres. I cannot go with them. Either you leave the place, vacate the place, and pay me the lease rent from 2004 till date.
Well, the executive case is this.
Or whatever fund has been sanctioned, that may be paid to me.
That much only. And they are trying to drag this matter.
That is the crux of the case, my lord.
Yes.
I cannot be forced to, my lord, acquire the land as desired by them, my lord. That is the whole.
That's all right, but you are occupying the land.
My lord, occupying is, my lord, as per the affidavit, my lord, this is very much clear. That affidavit, that under position, that is
No,
under.
no, as per, this is your document, no?
Yes, my lord.
Page number 45 and 40 and 40.
Yes, madam.
My lord, so
44 and 45.
How this mismatch, my lord, how
Huh?
this communication, my lord. My lord, at least they,
Uh,
I'll come with, my lord, detailed instruction, my lord.
something wrong with you?
My lord, in a main
You
case
are
also.
playing this game of hide and seek.
My lord. I'm sorry, my lord, my lord.
So being the Home Secretary of the country, it is uncalled for.
True, my lord.
That too before High Court.
True, my lord.
Hmm?
My lord, 2 days time may be granted, my lord, I'll come with the instruction.
Pardon?
2 days time may be granted, my lord. I'll come with detailed instruction. Since your lordship is in since till this week, till this week, my lord, my lord, on matter may be fixed on 6th.
Day after tomorrow, how much it is? Today is 3.
6. Today is 3.
Let it be 5 then.
5, lordship, I will be having personal difficulty. 5, 4 and 5. On 6.
See, yesterday he was absent. I had to cancel my going to zero. Again, today I have planned for going to zero after attending this case. So let us have on 5th.
5th, I won't be possible, man. Personally.
Otherwise, your lordship may dispose of the main case. If they agree, whatever they have done for making payment as per assessment made by the district administration and as per sanction approved by the competent authority. If he is ready to make payment, I will not pursue this matter.
Therefore, in affidavit, we categorically made a statement that this is the only case where we have been forced to, my lord, acquire the land.
One thing they
That
have,
is also not
they have played
permissible.
another game, my lord. They have played another game, my lord. As per section 19 of Lara Act, if the declaration is not made within 12 months, then acquisition matter lapse. That is called rescind. Almost same meaning. And they lapse it. They get it lapsed. After that, they have written a letter, so many letters, not only one, at least 5 letters they have written to Deputy Commissioner for fresh issuance of notification for acquisition, which cannot be accepted by me. So they are not coming to the court with clean hand and mind. I'm tired. But I cannot follow them. Today they will say something, tomorrow they will say another thing. That cannot be accepted, my lord. This thing is happening in this case.
Then in that case, my lord, on 5th, my lord, my brothers will appear on 5th.
On 5th, all right. Let me go today.
Heard Mr. Escoyan, learned counsel for the applicant, Mr. Petitioner, and Mr. Kato, learned Deputy Solicitor General of India. So all the respondents.
My lord.
And Madam Samgita
Sorry, madam. I'm
Lordship, I 4 and 5.
4 and 5. Respondent number 4 and 5.
1, 2, 3.
Mr. Kato for 1, 2, and 3. During the course of hearing, Mr. Koyang has taken this court through the page number 44 and 45 of the of this interlocutory application, and submits that in the aforementioned 2 letters dated 14/10/2015 and 8/9/2015, the respondent number 1, 2, and 3. Respondent number ITBP is respondent number
1, 2, and 3, my lord.
No, 1,
ITBP.
1, 2, 3, and 6.
1, 2, 3, and 6. 1, 2, 3, and 6.
Six could include, okay.
Respondent number 3. Here he has been representing this ITBP.
Respondent number 3. Yes, madam.
What is the last sentence? In their affidavit, at paragraph number 5, have taken a stand that it is incorrect to say that the ITBP has took the possession of the land that TCC measuring 187 acre of land under the direct possession of the Assam Rifle and ITBP thereafter from 2004. Whereas page number 44 and 45, which are the letter written by Commandant 10th Battalion ITBP, indicates that the land, the area under possession of the TCC is 187 acre, and the same is also indicated in the letter dated 8/9/2017 that the land size handed over to ITBP by Assam Rifle on paper is 187 acre. And as such, a clear case of perjury is made out against the respondent number 1, 2, 3, and 6. 1, 2, 3, and 6. And therefore, Mr. Koyan submits that an officer of the registry may be directed to file a complaint against the aforementioned respondents under section 190.
No,
190?
229.
190.
Perjury offense is 229. But required provision is under section 379, read 215. Bharatiya Nagrika Suraksha Sanghita.
IPC under section 193 and 199.
Well, the
Perjury. And under BNSS?
300, 229.
229.
220 penal provision.
229.
229.
229.
Corresponding to 193 of the IPC.
Corresponding to 193 IPC. 229 BNS corresponding to 193 IPC. At this instance, Mr. Kato, learned counsel for the aforementioned respondents submits that he may be granted 2 days time so as to enable him to obtain instruction in respect of the page number 44 and 45, the 2 letters dated 14/10/2015 and 8/9/2017 written by the ITBPN 10th Battalion of ITBPN to the Deputy Commissioner Upper Subansiri District, Daporizzo. Paragraph. Taking note of the submission of learned counsel for both the parties. Mr. Kato is allowed to obtain necessary instruction from the aforementioned respondent and apprise this court on 5th of
Well.
June. Accordingly, it is provided that SSL is the matter on 5th of June.
Well, I'm sorry, my lord, I'll be having personal difficulty. My brothers will agree.
Okay, all right.
Deeply agree.
All right.
I have taken the step to the private respondent number.
You are appearing for
For appearing for the petition.
petitioner, you are for petitioner.
Yes. Second step.
Or is still awaited?
May
You are for?
Lordship, in this matter, I'm appearing on behalf of Senior Standing Counsel, Tabatagum, Department of Health, Lordship. Lordship, affidavit in opposition, we yet to file,
Okay,
and within this week, we will file, Lordship.
within week, heard Mr. Tapak, learned counsel for the petitioner, and Mr.
Titato,
learned counsel appearing on behalf of Mr.
Tabatagum,
Tamatamu, learned standing counsel for the respondent number
1,
All
2, 3,
Help,
1,
help.
2, 3, help.
1, 2, 3.
Yes, Lordship.
Respondent number 1, 2, and 3. The learned counsel for the respondent number 1, 2, and 3 submits that he may be granted 1 week time to file the affidavit in opposition. There is accordingly allowed. Office note dated 2/6/2025 indicates that service report in respect of respondent number 4 is still awaited. What to do? You want to take fresh step?
I will take first.
Mr.
We
Tapak
can,
commits
it
that
is a
you
very
take
far away, far flung away. That manner, we can await also,
away.
await for some time. Till
Okay.
next day.
Rescission is the matter after 2 weeks awaiting
Yes,
service
after-
report
after 2
upon the respondent number 4.
Interim order is there.
Interim order passed earlier shall continue.
Deeply obliged, Lordship.
Number 24, answer.
My lord, I file a criminal revision petition challenging the order passed by the special court POCSO UPR on dated 15/3/2025. Your Honor, as per the order dated 15/3/2025, one of the minor victim who was already examined and cross-examined by all the defense counsel was recalled again on the application filed by the one of the accused person. Your Honor, may kindly come to the page number 22. Annexure 3 is the application of the accused person who has filed an application for the recalling of the witness, POCSO victim who was already examined. Your Honor, their ground was only, they have taken the ground, page number 22, para 3, that therefore, for the ends of justice, victim B may be recalled to put only a limited question whether police personnel had threatened you to falsely identify accused Senla Ronia and to give statement against him. This was the only ground. And on the basis of this ground only, Special Judge POCSO, Your Honor, has allowed this application and the order has been passed to recall the victim. Now, Your Honor, may kindly see the deposition of the victim, Your Honor. Your Honor, this case, the fact of the case is that prosecution case. These children, they were brought from the outside the state and they were subjected to prostitution. So they were subjected to prostitution, Your Honor. So that's why they have come across with too many people. They were sexually assaulted by many alleged accused person as a customer. So, Your Honor, she has very clearly stated in her deposition also, she doesn't know the name of the accused person, but she can identify.
No, that's all right, but at this it says only notice has to go.
Yes,
This is
Your Honor.
POCSO case.
Okay. So, Your Honor, meanwhile, my interim prayer is that interim stay may be given. The order dated 15/3/2025 may
Whether
be
you
stayed.
serve a copy of this petition to the additional PP or PP of this court?
I have not served copy to the PP of this court, Your
Why?
Honor. Your Honor, I have been directed by the state to appear in this case, so I will serve copy. I will.
Okay, we'll list the matter tomorrow. When the next date is fixed before the trial court?
August 2 August.
2nd of August.
2nd of August.
Okay,
Your
okay,
Honor, I
fine
will
then.
serve the copy to the PP and I will take a step against the respondent. Meanwhile, it's my humble prayer the order dated 15/3 may be stayed.
No, without hearing the other side, it's difficult to grant any relief. You have mentioned the matter in the morning.
Yes, Your Honor.
In the meantime,
my
you
lord.
could have served the notice to the PP. Third, miss, your good name, please.
K. Bagra.
K. Bagra, learned counsel for the petitioner. This revision petition under section 438 and 442 of the BNSS 2023 is directed against the order dated 15/3/2025 passed by the learned special judge POCSO UPIA in POCSO case number 20 of 2024, whereby one of the victim has been recalled for examination by the learned trial court. List the matter tomorrow. In the meantime, learned counsel for the petitioner shall serve notice to the learned PP. Rest shall list the matter tomorrow at 2 p.m.
2 p.m. October.
Any other matter?
Please, my lord. My lord, I will take hardly 5 minutes to complete the submission, my lord.
Pardon?
I will take hardly 5 minutes to complete the, my lord, submission. In fact, my lord, it was already hard the matter in the length and, my lord, to what extent, my lord, this hard was.
Perhaps I have not heard it.
Yes, that is why, my lord, I have to repress the lordship, that exactly what is the matter. So, in fact, my lord, I have a limited period as to why the respondent authority cannot be direct to clear my pending bill, MR bill, my lord. So, in this regard, my lord.
Madam, this notification dated 8 January 2021.
Yes, Lordship.
His claim is prior to coming into force of this notification,
Yes.
right? So you are to reimburse the cost.
Lordship, what I have taken, I have given statement in the affidavit is only that in the earlier, it was, MR was paid 5 lakhs rupees was
Earlier.
earlier to him. In the old, this one. Lordship, what is that? His MR claims was perfect. Medical reimbursement loss of claim was paid, 5 lakhs was paid already.
No, subsequently he has spent large amount of money for treatment.
That's true, Lordship.
He is entitled to reimburse the aforesaid amount also.
Lordship.
Because those costs he has spent the same prior to coming into force of this notification.
That's true, Lordship.
Then what option is available to you? You have to pay the amount to him.
Lordship.
Hmm?
I leave it to your lordship because
No, you say logically, is it not the proposition? Is it not the position?
yes, lordship.
Yes,
Only that the 5 lakhs where it has been paid was the ceiling limit, lordship. In that all MR. claim.
Ceiling.
Ceiling limit. In my affidavit, lordship.
At page number
Page number, lordship, 7.
7.
Yes, lordship.
Page number 7.
Yes.
Paragraph number?
No, paragraph 3, lordship.
Paragraph 3.
Page 7. Government affidavit. Of course, after that, lordship, this court, honorable court has also directed to clear the bill. Order was passed and then
This OM is still in force.
lordship.
It is still in force. This OM, it is of 2013.
Yes, lordship. No. This is not in force now.
Modified.
Yes, lordship. In place of this now, CMA has come.
And that is of 2021.
Yes,
His claim is prior to that.
yes. But then in 2018 itself, the officers said that in place of this, lordship, my page 9, lordship. Page 9, lordship. Second para. In view of the discontinuation of AP, this one, lordship, and replaced by new chief minister's yojana, some more time shall be required to streamline the medical reimbursement issues.
So, my lord, till filing or till passing of this order, it was on 16 August 2018.
Yeah.
And now notification came to enforce
So your expenditure for the period
period since 2017, March.
17?
Yes, my lord. I have submitted my expenditure in the since 23 March 2017. And thereafter, the department has taken the cognizance and admitted that the department was supposed to consider my case as and when the new scheme, Chief Minister Arunachal Arogya shall be commended. So this was already commended in.
And what is provided in this new scheme?
My lord?
What is provided in the new scheme?
New scheme, lordship, when the person is admitted in that hospital, the particular hospital, under the chief minister's yojana, lordship, the payment is given through the hospital, not to the person. So this cannot be lordship, of course, because their case is of 2017 till 2017.
The new notification of CMA, Chief Minister Arunachal Arogya
That is came into force in 2021.
Yes, notified.
8/1/2021, whereas my case is of 2017.
17.
Yes, ma'am. And by the 2018, my lord, the department has admitted that my case was supposed to
Where?
get that.
Where is that admission?
My lord, in view of the WPC number 24, while
Page number.
page number 54, my lord. My lord, last para, 54. In view of this, my lord, got it? In view of the discontinuation of the Arunachal Pradesh Chief Minister Universal Health Insurance Scheme and replaced by the new Chief Minister Arogya Arunachal Yojana KMA, some more time shall be required to establish the medical reimbursement issues. In view of the above facts and circumstances, authority is now unable to clear the medical reimbursement area and the petitioner until the state government revoke the order stated above. The petitioner's case would be reprocessed only after the procedure of the CMA is notified after the government policy decision. Hence, accordingly, this court order was disposed of. Therefore, my lord, this is the admitted fact that they are supposed to consider my case, streamline my case. After
No,
the,
if as per the Chief Minister Yojana, they are supposed to pay to the hospital where you have been admitted.
Arogya Arunachal Yojana, the complication of the department was that, my lord, at that time, the earlier one is the Arunachal Chief Minister Universal Scheme. But now, this at that particular moment, that Arogya Arunachal Yojana was not implemented. Now this implemented has already started. But Lordship, my case is not that. My case should be considered under this Chief Minister Arogya Arunachal Yojana. My case is that during that time, that is in the between 2016 and 17, their medical expenditure was there, reimbursement.
No, that's all right, but ceiling is there. Ceiling is there, 5 lakhs.
Madam. So far, madam, that so far the ceiling is concerned, that ceiling of the 5 lakh was, my lord, of the 2013 madam. But after the incident of after the notification of ceiling, my lord, my case come. So by 2017 only my case was considered and the board has considered. Therefore, my case was not applicable because that ceiling limit is no more existed during 2017 month. So therefore, the department
2017
has
ceiling was not in existence.
not in existence.
How, why?
Because, my lord, after the ceiling limit, my case has been considered by the department, and accordingly, my lord, this reimbursement bill was considered, my lord. And had that been implemented, the ceiling limit,
When it was considered?
my lord, it was considered by the board of the doctor on 23 March 2017.
2007.
2017. Therefore, my
At
lord,
that time, that ceiling was not there.
no,
It
dear
was
ma,
subsequent.
At the time,
subsequent.
Chief
Hey.
Minister Universal Health Insurance Scheme was there, which was in the form of reimbursement.
Had the ceiling limit was in the operation, my lord, my case could not
No,
have been
at that time,
considered.
it was not in operation. Madam, what was the page number of your affidavit? That ceiling?
Page number, what's it?
Yes.
Lordship, this is an office memorandum of 6 August 2000.
6 August, yes. So this ceiling came into force with effect from 6th of August 2013. In 2007, it was not there.
17.
No. Earlier claim. It was reimbursed in the year when? 2007.
17, my lord.
17.
17.
Acha.
Therefore, my submission is had the ceiling limit been operating at the 2017.
And where is the document to show that they have allowed, they have not considered the ceiling?
My lord, from the government side, my lord, I have not received it. So
Where?
for the government received it.
No. 17, it was reimbursed.
My lord, my bill was
Your
considered.
earlier
finally-
bill was reimbursed.
No, my lord, my bill was finally, my bill was considered by the board in the years 2017. Therefore, not being payment, I have approached this honorable court in the form of WPC number 24, and direction was made to consider. Therefore, while in response to that WPC, the government has said that because of this two scheme, the government is not in position to streamline. Now my submission is that now this scheme, Chief Minister Aragya Arunachal scheme has already implemented. Therefore, though I am not claiming on the basis of that scheme, but now the government has reason to consider my case, which my MR bill, which has been pending since 2017. Government was supposed to consider after the enforcement of the 2017. And so far,
What happened after the direction issued by this court in earlier round of litigation?
my lord,
Whether your case was considered by the
exactly, my lord, my case has not been considered. That is why I am here before the
as per direction of the earlier round of litigation,
my lord,
not considered.
not considered. And my lord, I have already submitted. This is in the last occasion, my lord. I have submitted this is the cover-up case. This honorable court has already, my lord, covered in the WPC number 02 of 2022.
Where is that order?
22/1/2024.
Where
This
is that order?
yes, similar order, and my lord, this was placed before the government and before the lordship. So, my lord, this was adjourned on the last occasion after hearing that whether government is to, my lord, just to, my lord, go through this judgment. And my submission is this is the same exact nature of the case, which is cover-up matter. So, in view of this WPC number 2, my lord, my case may be, my lord, disposed of with the same direction.
So is there any rule for reimbursement? Is there any rule for reimbursement?
No, man, no specific. There, so
No,
far
but it is stated in this order.
what
that
is, so far the rule procedure adopted by the department, all the department in the Malo, not only state in Arunachal Pradesh, Malo, that
It is, you see, in this order, page number 6, paragraph number 12. It is stated that under CS within bracket MA rules.
right.
What is that rule?
My lord,
Where is that rule? 1994.
page number.
It is page number 3.
My lord. It is specifically stated in the order that the same was under the MA rule 1994, which that is the bill pertaining to the medical reimbursement were accordingly submitted. And unfortunately, the mothers of the this is the so, my lord, this is the same pleading, my lord. What?
You produced this rule before the court. CS within bracket MA rule 1994.
My lord.
When?
As on today, my lord, this rule is not with me. So, my lord, if I'll try to produce it, my lord, by next week, my lord. Because As of now, my lord, this rule is not with me. But my submission is, my lord, as per this rule, my lord, I have
No,
submitted by
on the
MRB.
basis of this rule, the court has allowed this petition. Hmm?
My lord.
Madam, what is this rule? CSMA rule?
Lordship, that's why, Lordship. Uh, Here, Lordship, the CSMA rule, Lordship, I can, Lordship. The matter may be fixed on Friday, Lordship. I
Friday,
can
Friday,
try to,
okay.
In the-
Heard Mr. Modi, learned counsel for the petitioner, and Ms. Ite for the respondent authorities, Ms. Ite submits that she will try to find out CS within bracket MA rule 1994, within bracket SIC 1944. And she will place the same on Friday. Where is accordingly allowed, rest is alleged on Friday. Rest part heard.
Lordship.
Oh,